Welcome everyone. We're delighted that you can join us to discuss this very important topic, which is quickly approaching for EU states. Obviously, there are some whistleblowing protection already in the EU and globally, but this has become much more pressing because the EU directive, was passed in November 2019 with a 2-year implementation period. Now, obviously, we all know what happened in March 2020, which obviously caused some distraction for globally. And has meant that a lot of governments are behind in their implementation of local legislation to comply with this directive. That said, there are, a lot of global and multinational companies who have comprehensive framework requirements and policies and procedures for dealing with whistleblowers, but they will need to be changed in light of the directive. So that's what we're going to be discussing today. We are going to be very proactive and jump straight into a poll to make sure that everybody's engaged and listening. And what we are asking you to respond to is whether or not you know which jurisdictions that you have operations in. Have they prepared draft legislation to comply with the directive? So you can respond to the poll by scanning the barcode or accessing the link that you can now see. And we look forward to receiving those responses. So just to reiterate the question, do you know whether the jurisdictions that you operate in have prepared draft legislation to comply with the directive? I'm going to do a very brief introduction of the panel, who I'm delighted have joined me today. I'll then just very briefly go through some of the salient points of the directive, and then we'll get into our discussion, which I hope will be active and engaging. And I would say that if people want to raise questions during the discussion, we will try and take them as we go along and then at the end as well. So firstly, we have Nancy Reynolds joining us from Western Union. She's Managing Associate General Counsel and Chief Ethics Officer and she's based in Denver, Colorado. It is very early in the morning for Nancy, so we're really appreciative that she has joined us at this time. She has over 15 years experience in the employment law field and lots of experience in dealing with global ethics and whistleblowing issues. I should also thank Nancy very much because she recently got married and was on honeymoon and attended all our preparation calls while she was trying to get ready for her wedding too. So thank you very much, Nancy. Jose Carlos joins us from Sao Paulo in Brazil. He's a partner with our Jus Laboris firm there. Verano Avogados. Sorry, Jose Carlos, if I absolutely messed up that pronunciation. My Portuguese is terrible. So in working in the field of employment law, obviously, Jose Carlos routinely advises clients on lots of HR issues. He provides them with creative and business orientated solutions. He's been recognized by his peers for a very deep industry knowledge and subject matter expertise, and is consistently ranked by Chambers and Who's Who Legal. He handles litigation for his clients on confidentiality and non-compete issues, and also is very heavily interested in whistleblowing globally as well. And finally, then we have Soren, who is in Denmark. So he is on this side of the Atlantic, like me. He's an associate in our Danish Jus Laboris office of Norbom Vindig. He advises on all aspects of labour and employment law, as well as a keen interest in data protection and whistleblowing as well. Soren also spent, I think, maybe 18 months or 2 years working with my colleagues in our London office, and was a big hit there. So I'm delighted to have such an interesting and engaging panel for the discussion. So, as I said, although the directive was passed in 2019, a lot of EU and global countries have whistleblowing legislation. And what that does is it seeks to protect employees from retaliation or legal action for speaking out against wrongdoing. And as we'll see in industries like Nancy's, so financial services, pharma, we'd have seen protection like this going back a longer period of time. But the sectoral approach, rather, So protection for whistleblowers under particular regulations like health and safety or financial services was being used very little. And in actual fact, in a recent survey, 29% of Europeans thought that there was no protection for those who whistleblow. So on that basis, the directive was enacted, and obviously we also had very high profile leaks like the Lux leaks and the Cambridge Analytica, and the EU really felt that it needed to try and put a uniform obligation on member states to protect whistleblowers in their jurisdictions. The directive is pretty limited in its coverage in terms of who it covers, in terms of what it covers, so what breaches it recovers, and while it is limited to breaches of EU law, so public procurement, financial services, the prevention of money laundering and terrorist financing, product safety, public health. It does allow for member states to go wider than that. And I think that a lot of member states, as we'll see, have gone beyond what's just in the directive, and their local laws either already do or will cover breaches of local law in that particular state rather than just breach of the EU directive. In some states it is still under discussion though, and it's also worth highlighting that interpersonal grievances between employees, and for instance in Ireland, complaints that cover only the terms and conditions of an employee aren't covered by whistleblowing legislation either. The categories of persons will be widened. So people who are covered by whistleblowing protection will be broader. So while frequently we would have been familiar with employees being covered, it's now workers, self-employed people, shareholders, non-executive directors, volunteers, unpaid trainees, and people who no longer work with the organisation. It's just if the information that the breach relates to or that has been disclosed was acquired while they were working. It will also cover candidates for work, and then any third parties who are connected with the reporting persons who could suffer retaliation in a work-related context. So, for instance, colleagues or friends, where they are connected with the reporting person's employer. I wonder, is it too soon to return to the results of our poll and just see how whether people know whether the jurisdictions that they operate in will be or have already implemented legislation? It might be too soon. Oh, right. Okay. So we've got a good response. So that's a yes to 65%. I think I'm just going to, can we move left there? I can't quite see whether that's the yes or no, but we have a 69% and 31% split. Helpfully, we have a heat map on our use laboris. Oh, sorry, I just see now no is the majority, so that's quite interesting. So this heat map is very timely. What we can see here is what countries in the EU have taken steps to implement legislation that implements the directive. So you can go to the Use Laboris website, and if you hover over the various jurisdictions, it will tell you where they are at, and you'll see there Latvia is way ahead of everybody else. They have already implemented their legislation, implementing the directive. The countries with the next shade of the less dark shade of pink are the ones that have draft legislation, but it hasn't yet been passed. The ones in the lightest shade of pink haven't yet introduced draft legislation, so they are very much going to be under pressure to do that before the end of November, or the end of December, sorry. So let's start with some questions for our panel just about whistleblowing generally and how it's operated in their organizations or with their client organizations. And firstly, Nancy, if I can ask you that in your position as Director of Compliance and Ethics in a financial services global employer, you already had measures in existence to deal with whistleblowing, right? And I know that a US study has shown that companies that have these effective internal reporting processes experience better business performance. Can you just tell us a little bit about your experience to date and how you think that the introduction of the directive might impact your work significantly?
Absolutely. And Shubhra, thank you so much for that introduction and the overview of this directive. You covered so many important points. So you're exactly right. I lead the ethics office and the ethics program at Western Union, and that is located in the legal department at our company. And I am based in Denver, Colorado. But as many of you know, Western Union is a global company, and we have about 10,000 employees, 80% of which, so 8,000, are outside of the US. So I want to make sure I stress that point so that you know that we are in many different places, including many of the member states. So our company has had an ethics helpline for many, many years now, and we use a third-party provider for that purpose to allow employees to raise concerns. We also have a code of conduct, and that is a document that is public. It's on our investor relations page. And we encourage employees to come forward to raise concerns, and we continually stress a speak up culture. So these are things that we're doing that I think will help us be well prepared, even though we know there are many open questions about how the directive will actually be implemented in member states. And then we really stress a no retaliation position on the part of the company. We actually do surveys with our employees to ensure that they feel comfortable and confident in the company's commitment to no retaliation. And we address comments that we get about that just to make sure we're really clear in setting strong messages of no retaliation, a tone from the top on that piece. And also we ask in these surveys, do our employees know about our ethics helpline? Do they know about just different ways and resources to raise concerns? And are they comfortable using them? So having a strong speak up culture, and Shubhra, exactly what you mentioned, the value that whistleblowers bring to companies, the business value to raise issues early on and help companies address issues is something that we've been working on. As far as the directive, one thing that's really critical is a response time and making sure that managers and anyone who's receiving complaints that could be viewed as a whistleblowing report escalate that and get that to the right source so that we can respond to reporters in a timely manner and also make sure that we're conducting investigations in a timely manner. So I've touched on a lot of things. I'll take a pause and see if there's anything else you want to talk about now, or we can address more things as we continue.
That's really helpful. Thanks, Nancy. Yeah, I think all of the things that you raised we'll probably be touching on as we go through our chat. But and there is a lot, I think, to talk about, because I think that traditionally when people think about whistleblowing and addressing the directive, they probably only focus on the retaliation piece, because that's obviously the highest profile around whistleblowing. But the directive, I think, introduces more obligations which really bring in the reporting, the investigation, and the retaliation. So there's, it I guess maybe brings the two other aspects of reporting and investigation up in terms of employers' obligations, and then you'll still have the retaliation piece as well. So that's very helpful. For Jose Carlos, we'll stay on your side of the Atlantic and the LATAM region. In my introduction, I was talking about the fact that some laws, or rather whistleblowing isn't necessarily a new concept, because in some regulatory frameworks there was already protection against penalization or victimization for having tried to raise issues. If, like in your jurisdiction, there isn't an overarching whistleblowing protection, and only some types of wrongdoing are protected, do you think that global and multinational employers will, if they have operations in Latin America, the same as in EMEA, that they will just reproduce their policies for LATAM, even though it's not obligatory?
Hi, Shira. Yes, absolutely. I think that multinational companies have been doing that already. I've had clients that for years kept whistleblowing protection and reporting channels, either by their own or independent. What we don't have yet, and we are not exactly at the point of implementing, is something similar to the European directive. We don't have any thorough or deep piece of legislation as in Europe. What we have is what we see in Latin America is that in some countries like Brazil and Peru, there are specific laws that address integrity issues within public contracts, but nothing as comparable to the European directive. There are some bills of law. I think in Argentina, there's an interesting bill of law that provides additional protection to whistleblowers. This might come out as an interesting piece and perhaps an example to other Latin American countries. But what we have also in Brazil is not only multinational companies replicate their programs here, but also local companies replicate the rules of the Clean Companies Act. Companies are incentivized by the Clean Companies Act to have their own reporting channels and to provide protection to whistleblowers. Many companies take the initiative of replicating or expanding such program to their private agreements and to their business in general. I think that this need of Brazilian companies and subsidiaries of being key players in the international market will somehow induce them to tag along and follow the European directive.
Thank you. And interestingly enough, because it's a question that I'm always interested in, because are there laws in your jurisdiction that whereby whistleblowers can be financially compensated? Because we have a question. I'm asking you this, but then I'm going to go back to Nancy. Our first question from the audience is, what have you found to be the most powerful tool or communications vehicle in terms of encouraging employees to speak up? So what's your view on the financial compensation? Do you have it and does it work, or are there other tools or communications that help people to speak up?
No, we don't have anything similar to that. Matter of fact is that it really comes or sounds a little bit strange to us that somebody could be rewarded for fulfilling a legal duty. I understand the notion behind it, but in our legal system, it might somehow incentivize false reports. We may come back to that later, but one of the problems I've seen in companies implementing reporting channels in Brazil is that people weren't exactly aware or completely in full understanding of the implications of their reports, and many of the reports were absolutely irrelevant or unrelated to ethics or compliance in general. I think monetary incentives would sound minimally strange, but somehow might induce unsubstantiated reports.
Thank you. And Nancy, from your perspective, what have you found to be the most powerful tool or communications vehicle? Because I know I had a look at your code of conduct and also your ESG report, which is really impressive and obviously very reassuring for your shareholders to see that you do have an ethics helpline, both email and telephone, which encourages employees to speak up on a 24/7, 365 view. Have we lost Nancy? I think we may have. We might move on and come back to that. Soren, I'm going to ask you about a particularly interesting issue, and that's around the reporting channels. As I said, there's a much bigger focus on reporting and investigating in the directive and not just the retaliation piece. And one of the key changes is that organizations that are in both the private and the public sector who have more than 50 employees will be obliged to create effective and efficient reporting channels. Now, for instance, at the moment in Ireland, it's only public sector employers that are required to have a whistleblowing policy. So now that's going to apply to all employers here. And in some cases, depending on the industry, the threshold of 50 employees may not apply, even if you have a smaller one. That may that you might still be obliged to have this. But the requirement to establish channels and procedures for internal reporting and follow-up is going to be to individual entities. So if you have entities, if you have a number of entities in a jurisdiction, if they're separate, they will be required to have a separate reporting channel, and they won't be allowed necessarily to have one reporting channel. And in fact, the EU Commission has issued a letter of clarification because somebody asked about this. And they said each legal entity with 50 or more workers is required to set up channels and procedures for internal reporting, even where they belong to a group. Now, I should clarify that for employers who have between 50 to 250 employees, they have a 2-year grace period. So they will have until the end of 2023 to put these frameworks in place. But I know that in Denmark, in June, a law was passed adopting the directive, and the extent to which group companies can have a central approach is being very hotly debated where you are. So tell me about the Danish approach to this.
Yes, thank you very much, Aoife. You are absolutely right that this particular topic is being very hotly debated at the moment, not just in Denmark, but in many other member states. And I'm afraid, though, that we here in Denmark started this debate by asking the Commission questions about this topic. But I'll try to just give a quick rundown of the process we've had here in Denmark to show what the issue actually is. You mentioned it a bit yourself, Shifra, but it follows from the directive that legal entities in the private and public sector need to establish channels and procedures for internal reporting and follow-up. And as you said, the legal entities in the private sector has to do this where they have more than 50 or more workers. But then in Article 8.6 of the directive, it says that legal entities in the private sector with between 50 to 249 workers, they may share resources as regards the receipt of reports and any investigation to be carried out. So obviously it follows from this that illegal entities with between 50 and 249 workers, they can share reporting channels. But what about those legal entities that has more than 249 workers? Can they not share their reporting channel with other legal entities in their own group? And this was clearly a question that the Danish government puzzled a bit with when they were preparing to introduce a draft bill to transpose the directive into national legislation. And just to give you a tiny bit of context, we do not in Denmark at the moment have any whistleblowing specific legislation apart from the sector specific requirements that also follows from EU directives. But the situation is here and was here that many companies who already operate a whistleblower scheme, they was doing this on a voluntary basis and in most cases on a group level or at a group level. And that was run by a centralized team, mostly owned by the compliance team or ethics team. And the Danish government was keen to understand whether this way of doing it could be continued under the directive and the way we have to implement the directive into Danish law. So the Danish government contacted the EU Commission about this topic, and following this correspondence, they sent out a draft bill for public consultation. And in this draft bill, it was made clear that group companies cannot, unless they have between 50 and 249 employees, they cannot share reporting channels. And this was, of course, because what you referred to before, Shifra, that the EU Commission has said that each legal entity must have their own separate reporting channel. And so when this draft bill was sent in public consultation, there was a bit of uproar about it, but the position in the draft bill was not changed when the draft bill was put before the Danish Parliament. And yeah, it was introduced as a bill, and when it reached the committee stages in the Danish Parliament, all hell broke loose, to put it simply. a large number of Danish companies made submissions to the committee in the parliament about the issue it causes that they cannot share a centralized reporting channel as they do today. And they were questioning why there would be any advantages in this, both for the whistleblower, but also for companies. And the Danish parliamentarians actually listened to this, and after a few months of debate here in Denmark, the final bill was put before the parliament for a vote, and it was actually changed, this position now, so that in the legislation we have enacted here and that will come into force at the 17th of December, group companies will be able to share their reporting channel. And there is a but. There's a slight but, because there is a mandate for the Minister of Justice to revoke this possibility to share reporting channels. But he may only do so, the Minister of Justice, if it is at the time of the implementation deadline 100% clear that this way of implementing the directive will not violate the directive. And it is though very clear that the Danish Parliament and the government will fight hard to maintain this position, along with the Danish companies, of course. But this is where we have ended up for now in Denmark, and then we'll have to see what is going to happen up until the implementation deadline. And I know there's been many companies, not just in Denmark, but all across Europe, who reached out to the expert committee in the EU Commission to ask them for clarification of this position. And the EU Commission maintains that position, that it is not possible for group companies with more than 249 employees to share reporting channels. So we feel like we have clarity in Denmark, but it still may change. And I know, of course, that many other member states are following what is happening, maybe not so much in Denmark anymore, since we've now passed our legislation and just waiting for the EU Commission to do something. But that is where we are here at the moment. I know there's a lot of other EU member states who have not passed their implementing legislation yet, and who does not really know what to do about this issue, but it's very much on the agenda now. So yeah, there was a bit about what has been going on here.
Okay, thank you, Søren. That's really interesting, because I think that's a key message to get across here, which is that people, people in legal, people in HR, in-house, they really need to keep an eye on timings on this, because obviously while the implementation period is the end of this year, I would imagine that so many governments are way behind because of COVID, and it will be interesting to see whether the EU comes down heavily on them because they haven't implemented the directive, or whether some leeway will be given there. And also then it will be interesting to see who's brave and follows the Danes in terms of the group, the reporting channels. Nancy, we lost you there for a bit. We're glad to have you back. Can I come back to the question that we got from one of our audience around what you found to be the most powerful tool or communications vehicle in terms of encouraging employees to speak up? And just to confirm, I did have a look at your code of conduct and your ESG report, which I was saying must be so reassuring for your global shareholders to see, just how high up on your priority, or Western Union's priority list, this is. But what do you think has been a very powerful tool? And I did also say that you do have this 24/7, 365 email and telephone number ability to report.
Yeah, thank you, Shubhra. Well, I think what is most critical to employees is two things. One, to know, is the company actually going to do something? Will some meaningful change be done? And will the company take my concerns seriously and treat them in an objective, neutral manner? Let me know if you can still hear me okay. I'm getting a message that my quality is not great. Okay.
No, I can. That's good.
Okay, excellent. All right. So I'll keep going. So that, I think, is one concern. That's a way to address that is to speak publicly about the investigation process. So we actually do trainings with different groups in the company. I mean, we kind of demystify what our process is, what the investigation process is, how we receive complaints, how we work through them, the importance around maintaining confidentiality to the degree practicable. And we even do trainings based on anonymized case studies. So we'll say, we're going to describe a situation, we've changed the facts somewhat, we're not using names, but to give people an idea of the kinds of issues that are raised and how the company responds. I think that gives people confidence in the process. So one reason people don't come forward is they think there's nothing that's going to come of it. And then maybe the greatest concern people have is a fear of retaliation, that they will be viewed negatively by their peers, their manager. It will affect them from a financial perspective. So reiterating that message is something that we do over and over again. And we take any complaints of retaliation very seriously. So even if an underlying report were not substantiated, if someone felt like they were retaliated against because they complained, we then look into that. And those are two things I think that you cannot repeat often enough. And our experience is that in most cases, people do want to give the company internally an opportunity to address issues. There are situations in the US and other locations where people can go to external parties, and I understand the EU directive has kind of a 3-tier system, but the degree to which you can drive internal reporting, I think, is very positive. And if you can address those two hurdles, will the company actually do something, as in look into the matter and treat me fairly, and will the company protect me from retaliation? So we really focus on those messages.
Thank you. And what do you think about these prescriptive timelines that the directive has introduced, which is that there must be an acknowledgement of a report within 7 days, and then there must be feedback, i.e., there must be information to the employee about the investigation or closure of the investigation within 3 months. And it can be 6 months in exceptional circumstances, but it's 3 months from the date of that feedback. For somebody in your role where you're looking after investigations globally, and I think that investigations are done locally in accordance with local law, do you think that's a very tight time frame?
It can be. It can absolutely be tight. And you want to ensure that you're appropriately staffed for something like this, because complaints can come in waves, and you have to be prepared to be responsive and meet these timelines. And you're right, in jurisdictions like, for example, the UK and other jurisdictions, there are a lot of processes we have, whether it's maybe a grievance process or a disciplinary process that we need to follow, that will just take a longer period of time. What we have found is that if we do check in with the employees and let them know, where we are in the process, how things are proceeding. If there's not anything we can share, then we don't. But it does seem to help reporters know that we just stay in touch with them. But currently, we have a very quick response when we receive complaints. What I mentioned earlier, which I think is a tricky piece, is ensuring that complaints we can address the ethics helpline complaints. We know when those come in. But if a complaint goes to a manager in a regional office, that manager may or may not understand that they just received a whistleblowing complaint. So we do a lot of education with our managers, and HR is critical here to really reinforce this messaging and to have their ears open and be listening. Could something be perceived as a whistleblowing complaint? And if so, then to make sure they're following these guidelines and timeframes.
Thank you. Yeah, it's going to be, I think, challenging for companies that may not have already had some kind. I mean, a lot will have, but some may not have had particular regulatory requirements to have these types of complaints procedures and frameworks. So it could be quite challenging for them in terms of implementation when the time comes. Jose Carlos, I know that you're particularly interested in confidentiality, and I think that in terms of speak up policies and encouraging employees to speak up, and the directive really does focus on making sure that the various channels are signposted to employees, and that they that they know where they should go and how they should go about reporting. But a big issue for employees would be maintaining confidentiality. And the obligation in the directive is that the internal channels must be designed or operated in a way to ensure the confidentiality or of the identity of the person making the report and any third parties mentioned, unless the disclosure of the identity is required to enable the organisation to investigate it. The directive does allow member states to decide whether legal entities will be required to accept or follow up on anonymous reports of breaches. But what do you think organisations can do about that in terms of reassuring people around confidentiality and maintaining that confidentiality in the context of trying to run a transparent and objective and fair investigation into the complaint they've received?
Well, training. You have to train your staff. You have to train your investigations team. You have to have people who have not only training, but also the skills of being sensitive towards interviewees and being able to follow these specific routines and specific procedures that the company has in place. I think that confidentiality comes as a challenge because at some point, some degree of disclosure is necessary. Interviews must start with very broad and general questions addressing the workplace in general and trying to collect information without inducing the interviewee to provide specific responses or leading the way. But at some point, depending on the nature of the report, if the report is quite specific about one fact, one situation, and that in the interviewee is possibly a designated witness of the fact, you may need to have some degree of disclosure. Therefore, I think that an essential part of all such programs is a pledge of mutual confidentiality that the interview team has to make at the beginning and at the end. I always advise clients to produce minutes of the meetings in writing, and in the minutes of such meeting, the companies also can reinforce their pledge to keep confidentiality, but also to warn the interviewee or whomever is being part of that process that they must keep all such information as confidential.
And actually, the directive does include, as part of the record-keeping obligations, that the reporting person should be given the opportunity to check and rectify and agree minutes of the meetings, which I know from helping employers on investigations and the bar on investigations, particularly in Ireland, is very high, and that of itself can be a nightmare, where you have somebody who says, no, that doesn't accurately reflect what was said in the meeting and I'm not signing or agreeing them.
Sure.
That can be difficult to move on from. I think we also should just flag for the audience that the list of retaliation is also somewhat expanded, in that retaliation isn't just I blew the whistle and I got the sack or I was dismissed. It could be negative performance assessments, any disciplinary measure, failure to convert temporary employment to permanent. So it's very important that people, keep an eye on developments in your country or in jurisdictions where you have operations. Stay on the Jus Laboris website. It's really informative on this topic. About developments in regard to the timing, but also, what is covered. Has the local government gone further than the directive requires, and gone further and implemented, you know, even more onerous obligations. We did get another question about the common reporting channel that Soren was talking about, which is a common reporting channel for a group of companies allowed only in Denmark, but not allowed, for instance, in Sweden. And it's not necessarily that Denmark have been allowed to do it, but they have taken a view for the time being that this is the way they're going to do it. Sweden have draft legislation. It appears that, well, we think that they're staying with the single reporting channels per entity. But this information is definitely available on the Whistleblowers website. There's a helpful article there that should be able to answer that. I'm really conscious we've only got about like 7 minutes left, and we haven't covered a lot of what I wanted to cover, but I did say that I would give each of my panel about 2 or 3 minutes to tell us what their top tips would be, and you know, what practical steps employers could take. Before I start that, I do want to run a final poll, which is for people. Has your organization taken steps to prepare for implementation of the directive, bearing in mind that some jurisdictions don't have draft legislation in place? So again, if I can just ask people to scan the barcode or go on to the link to vote on that. But practical tips and things to watch out for. Jose Carlos, can I go to you first?
Oh, absolutely. I think I gave a spoiler of my last tip, which is training is never too much. Not only you have new members within your staff, but also you have to remind people that the company takes not only investigations, but confidentiality duties and privacy mostly very seriously. Our recently approved data privacy law is still depending on having a clearer position of the national regulator. So there's a big question mark on how the authority will handle issues of breach of data privacy breaches. So training is essential to be to make sure that you are in good shape, to make sure that you are not, or to the best extent possible, not violating any of such principles. As we don't have a directive like in the EU, at least we still have some general principles of law or related laws like privacy that must be observed.
Thank you, Jose Carlos. And Nancy, for you, what top tips would you have for global employers in terms of the implementation of this directive and what steps they can take to best prepare for it?
We've covered so many great topics. It's really actually been a fun panel to be on and interesting because this is so real time and in development. We didn't get a chance to talk about the burden shifting of retaliation to the employer. So that the shift would be the employer would be responsible to show that any kind of retaliation was not, or any kind of business action act was not in retaliation to a whistleblowing complaint. And so that really goes to ensuring that you have a good objective business reason for all of the actions that you're taking. I know a lot of our audience is human resources, which is such a critical, they play that organization, they partner in such a critical way for this EU directive and preparing for it. And so I think my tip for this group would really be for the employment law team at your companies, the HR teams to come together, privacy, if you have an ethics or compliance team, talk about everything you've heard today, do everything you can to research this and work in a cross-functional manner, because you have to connect a lot of dots and there are a lot of pieces, and you'll be much more effective and stronger, including your executive team and the tone at the top. So bring all of these people together to help address this issue. And then keep in mind too that whistleblowing can be a great benefit to the company. If you have employees raise concerns early on as a company, you can address these things, and that can actually add great value to the company.
That's very helpful, because sometimes I think that people who make these kind of reports can be seen as troublemakers, and they can, you know, particularly if their manager finds them difficult they can be, it can be, they can be seen and they can be potentially targeted. Like we had a particular case in Ireland 5 or 6 years ago. It didn't involve a whistleblower, but it was a claim whereby, the court was quite critical of the employer because they said, even though she had a number of complaints, you clearly just thought she was a pain or, a thorn in your side. You should have looked at each complaint individually and investigated it if it was a serious complaint. So that's very interesting. Thank you. Soren, what about you? Any top tips from your experience of whistleblowing in Denmark for anybody who's going to be preparing for the implementation of the directive and looking at their whistleblowing framework?
Well, obviously, just on that point I spoke about earlier, I think it's very, very, very important for multinational companies to monitor the position in the different EU member states, whether they will allow group reporting channels or if they will not. I think that'll be very important to look at over the next couple of months, just to see how that all pans out. I think that it really goes back to something Jose Carlos already said. I think it's really important to draft a really, really good whistleblowing policy to make it absolutely clear what can be reported about and what cannot, because you will help yourself so much if you have defined it for both your whistleblowing team who looks at the report, but also for the whistleblowers, what can be reported and what cannot be reported. Because you might, if you don't get to do that, you might end up sitting looking at complaints about the coffee or stuff like that, and that does happen. I see that quite a bit. And that's also a point that relates to a good whistleblowing policy. Really is the point that we talked about regarding confidentiality, because there will undoubtedly be situations where it'll be hard to investigate something without having to disclose the identity of the whistleblower. And obviously, because there is this confidentiality obligation, you are sometimes simply not in a position to disclose it, and you might have to. Your investigation might be limited, or you have to stop it on that basis. And I think it's important that is made clear in the whistleblowing policy as well, so it's transparent to the whistleblower, so they know this. Obviously, they're welcome to raise a complaint, but they should be told that sometimes that actually can be something that we have to take into consideration when we're investigating something. And then obviously, I think one thing that is important to monitor as well is what the investigation obligations will be in the different member states, because it is not that well defined, I'd say, in the directive. And in the Danish implementing legislation, it is not that clear either. So it's important to look at whether there is some specific guidelines or some specific requirements you have to follow for when the directive is fully implemented.
Yeah, because it does talk about this kind of 3-tier that Nancy spoke about earlier, the reporting that you can go internally, and then there's this expectation that there will be a competent authority at member state level. So here there's going to be an ombudsman for protected disclosures. And then the 3rd tier, which is to go public. But it's very important that employees are clear on that there might be a different threshold. If they're going to go public, for instance, they may need more than a reasonable belief, which would be okay for an internal disclosure, just for them to get that protection against the retaliation. I mean, it could be that they will make these reports, but they might not get the protection of the whistleblower's protection, depending on the way they make the report and how they make the report. We are bang on time. I'm so appreciative to Nancy and to Soren and to Jose Carlos for your input and all your time on preparing on this. We had a number of calls and you were really giving of your time and your knowledge and experience. So thank you very much to you. Thank you to our audience for listening and engaging. We might just quickly show the results of our last poll. Okay, so it looks like a lot of organizations are waiting to see what the domestic legislation requires. 63%. A brave 19% say they are already subject to changes in domestic legislation, and then we have another 19% who have it on their to-do list. So with that, I'll close the session. Thanks to everybody at Use Laboris for all your brilliant technical expertise in getting us through this as well.